The next matter to come before the court this morning is Midfirst Bank versus Chapman. Both sides, well, we have one side arguing this case this morning. It's my understanding that the applicant did not file a brief.
That's my understanding.
You will have 15 minutes to make the arguments regarding this case this morning. I'm keeping the clock, but I guess there's no need to reserve for rebuttal. We've read the briefs and we're ready to proceed when you want.
Thank you. Good morning. May it please the court. My name is Joshua Limmerman from the law firm of Goldman and Rosen. On behalf of the appellant Dara, Greene, Chapman, I first want to thank the court for rescheduling this matter. We'd originally been set to be before you on October, so I thank you for accommodating us. Just a little bit of a factual background first. The reason this case began was because Midfirst Bank had sued Ms. Chapman and her siblings trying to foreclose on a property that she'd been living on since 2008 when her mother had passed away. Now, she might have had access to some sophisticated estate planning at the time because the property was left to all 6 of those siblings. And as a result, Midfirst Bank, when Ms. Chapman asserted that she was still in residence and that she'd been paying all of the costs of the residence, Midfirst wouldn't negotiate with her. And actually behind the scenes, my colleague, Mr. Russell, who prepared the brief in this matter, had secured the cooperation of all but one of the siblings to try to cooperate and renegotiate that loan so that we could have avoided all this. But there was one holdout or one that we couldn't reach. So it's really a shame that all this could have been averted. But then what happened after that was that Midfirst failed to demonstrate that they had even accomplished service in this matter, and the case was dismissed. And then my colleague, Mr. Russell, who had a cross-claim already filed as well, voluntarily dismissed that as well because he certainly didn't want to go forward with the closure. At that point, after 5 years of living in the home and the foreclosure dismissed, this case was closed. And it was at that point that Midfirst Bank belatedly filed what they titled a motion to reconsider, trying essentially, by its terms, to open the matter back up.
The trial court's entry referenced this as a motion to vacate.
It did. I don't know why it did that. I believe that was a misnomer. That was an error by the trial court. It was clearly titled a motion to reconsider. And as this court knows, and as there has been a long line of precedent in prior cases law in Ohio, that the civil rules only permit a case that once it is closed to be reopened by a motion to vacate in compliance with Rule 60B of the Rules of Civil Procedure. There was no even any broaching of the factors from Rule 60B, the terminology of a motion to vacate. None of that was applied here.
And counsel, I'm sorry, I'm going to stop you not because of any reason, just to make sure, you do not represent the bank, do you?
No, I'm here for the 11th.
I thought you were. I just wanted to be sure that we weren't moving forward too quickly. Sometimes I do that. Thank you.
Not at all. No, understood. So they didn't file a motion to vacate. I know the court's order referenced it as such, but in the filing, if you looked at the court docket, it's not called that. It doesn't cite 60B. It doesn't cite any of the 5 factors that permit for 60B to vacate any judgment applied by the court. So,
what was their reasoning?
The reasoning, it must have been just a misinterpretation, just to say we're deeming this like a motion to vacate and there was some kind of accident with service. I think that was what the explanation or excuse that
They said something to the effect that they didn't get the notice to dismiss.
Right, it was some kind of a...
The court said, we're going to dismiss this if you don't show cause, and they said we didn't receive that.
Yeah, there was some kind of fluke or miscommunication that they had alleged, but...
I'm going to come out of left field here, but ask you another question. So, we know that the law says you can't file a motion to reconsider in a final order.
Right.
If the court grants a motion for reconsideration and reinstates the case to its docket, how do you have a final appealable order on that?
And you have a final appealable order on the,
Well, what she did was, whether it was right or wrong, what she did was she reinstated the case. There was definitely, I shouldn't say definitely, but I understand your argument. I shouldn't say I buy it or don't buy it yet, but your argument was it was a final appealable order. It was a final order when she dismissed the case to begin with. So
Yes.
therefore, it's not subject to a motion for reconsideration.
No, nothing is. It's a nullity under the law.
Right, okay, so she grants that, and she reinstates it. How is that immediately appealable?
Well, it all happened within the span of about a week.
Well, I don't know that that matters. What I'm
Okay.
getting at is, why can't you just appeal this at the end of your case?
Well, the expense for one, I mean.
Well,
I
the
mean,
law says expense doesn't matter.
Right, understood.
I don't mean to be putting you on the spot, I'm just.
Not at all, and this issue wasn't briefed, and.
Because they didn't file a brief, I know, but we have to look at our jurisdiction ourselves.
Understood, completely. I mean, there are a number of rules that, I wish Midfirst had, seen fit to follow when they were pursuing this action. Whether this is a final appealable order, I say it is because this case was dismissed. That is the final appealable order. Now, I see that what we're appealing from undo
It's
that.
not the
all
dismissal. Yeah, that's the problem. You're appealing from the reinstatement.
Right. So that I will grant you, but I will also agree, or rather I will say for the record, that that this court should exercise its jurisdiction because this is an error of law. It is a nullity to grant a motion for reconsideration. It's not something that this court can pay any heed to, and it needs to be overruled, and the case should be closed as it had already been closed. Nothing, and I'm going to cite Pitts versus Department of Transportation, 67 Ohio State 2D 378, that once an order is journalized, it cannot be modified, vacated, except as provided by rule. That rule being 60B. And forgive me, of course, indulgence. The City of Greene versus Clare from this 9th District. Just the last year, 2014, Ohio 1605. A motion for reconsideration like this one filed here is a legal nullity, as are any judgments or orders flowing therefrom. Nothing can follow this. The case needs to be restored to its, dismissed, closed status, because anything that should flow from granting a motion for reconsideration is a legal nullity, and there's really nowhere to go from there. And I'll add that also, on our side, we filed a voluntary dismissal of our cross claim. So the court is divested of jurisdiction from those claims as well. So, however, the Midfirst, the appellee, was trying to, in some way, in the wrong way, get this case back open, was improper. It did not follow any of the 60B provisions whatsoever, and therefore, the decision to grant the motion to reconsider, however you want to term it, should be overruled.
Thank you, counsel, for your presentation this morning. The court will take the matter under advisement, issue a written decision, which will be mailed both sides, as well as posted on our website.
Thank you very much.
Thank you.